Judge Collings and I are going to go through the advisory committee, the proposed amendments to the Federal Rules of Civil Procedure. Just by way of background, Francis Fox and I were on the advisory committee on the Federal Rules of Civil Procedure when we first started looking at this issue of should there be separate rules to deal with the discovery of electronically stored information. This is back in 1999. And that precipitated a series of studies which led to the 2006 amendments to the rules, which I think you all are familiar with. Not long after the rules in 2006 came into being, the advisory committee began to hear from judges and lawyers that they really hadn't solved the problem, which was excessive discovery, costly discovery, hadn't really helped much at all. So in 2010, the advisory committee convened a conference at Duke Law School where they looked at these issues again, which is, okay, we made some changes in 2006. They don't seem to be working. What should we do? And that conference precipitated, quite frankly, the rules that Judge Collings and I are going to discuss. Judge?
Yeah, the rules, a little bit about the procedures. They've been just set out for comment, so they've just been released, and there is a comment period ongoing. You can comment online, and I would encourage any of you that have any comments about these rules to make them, because the advisory committee, as Judge Carroll will tell you, or Dean Carroll will tell you, does look at those comments and considers them. What will happen is that after all the comments are assembled and any changes made based on the comments, the matter will go to the Judicial Conference, who will then probably authorize them to be sent to the Supreme Court. And then what the Supreme Court does, if they don't have any changes, they send it to Congress, and Congress has a certain period of time to make changes. If they don't make changes, then they go into effect. And if that process goes as it has in the past, these would become effective on December 1st, 2015. So we've got a little ways to go. The rulemaking process is rather slow. But that's the process, and as I say, if you have any comments, I'm sure the committee would like to hear them. The other thing that's sort of a wild card in all this is we don't know what Congress will do. The Judiciary usually just holds its breath and hopes that Congress is involved in other things and doesn't pay much attention to the rules. Congress, as you can imagine, the Judiciary doesn't see Congress as being that good at drafting rules of procedure. However, there very well may be some congressional hearings. There may be some congressional action on them. Senator Coons of Delaware, who's on the Judiciary Committee, has expressed some interest in the rules process and some interest in some of these issues that the rules are trying to deal with. So that may occur. So stay tuned. But that's the scenario as it is likely to be played out.
And we have divided up these rule changes, Judge Collings and I, to sort of get an initial comment and then a further response. I'm getting Rule 1. For those of you that are civil procedure junkies, this rule has not been amended since 1938. So this is a fairly major step, the notion that Rule 1 ought to be amended, and it is being amended to add that language, and employed by the court and the parties to secure the just, speedy, and inexpensive determination. What this is intended to communicate is the federal judiciary's view that cooperation among lawyers in the discovery process is absolutely critical, that this is designed to flag that issue, to put it in the forefront, that the answer to these problems lies in cooperation between the parties and the intervention of the court. It's also designed to emphasize, again, up front, what everyone believes is the key to reining in discovery, and that is active intervention by the court early and often. Judge?
Yeah, I don't have much more to say. It's aspirational, and I think it is frankly questionable as to what effect it will have in the long run. Prior to the amendment, as the rule stands now, it's sometimes invoked to support a particular course of action. But it's very general, very aspirational, but it just gives you a sense as to where the judiciary is going with respect to what they're requiring parties to be thinking about.
We had a very interesting conversation last night at dinner about what the duty of cooperation really does mean in the context of e-discovery, and that will be fleshed out as we hear more and more about this particular rule. Now I'll go to Rule 16B, which is another change in the rules.
Okay, Rule 16B, as you know, is the rule that deals with the scheduling conference before the trial judge, which occurs early in the case. Some of these are not particularly earth-shattering, others are more important. It deletes the language about having a scheduling conference, quote, by telephone, mail, or other means. The committee is pushing for direct simultaneous communications, that the idea of having it by mail doesn't seem to work, and everyone views a conference as being held in person as being the most effective means of doing it. It may be also held by telephone or by sophisticated electronic means. I don't know if that means that each council puts on their Google glasses.
I think that's what it means, yes, that's right. But again, I think this is this early and often intervention by the court. There are a lot of districts where there were mail-in scheduling conferences, and so the court never really got actively involved in the discovery process, and I think that's the major reason for this change.
It changes the time for issuance of the scheduling order from 120 days to 90 days after the defendant was served, or 60 days after any defendant has appeared, and adds to the possible content of the scheduling order a provision for preservation. And I think we'll probably be talking about this a bit later when we're getting into the sanctions area, but of course the real problem with respect to preservation occurs probably prior to the suit actually being filed, where lawyers get notice of the possibility of a suit. And you know that the common law rule is that you need to preserve when you reasonably anticipate litigation. And it's a real problem prior to the time when you actually have a complaint, and you can really put your hands around exactly what's being claimed by whom. But as I say, we'll talk about that later. But this actually puts on the provision for, in the scheduling order, a provision to discuss preservation. If there are any issues, now that the case has been filed, an issue has been joined, if there's any issues about preservation, you've got a judge up there to give you guidance, whereas you don't have a judge to give you guidance when you're trying to wrestle with these problems prior to the time that a complaint has been filed. So I would say that that's an important addition to put that on the agenda, and it's an opportunity for counsel who have gotten preservation letters that they believe are far too broad, and to get some help from the court in narrowing that, and I'd urge you to take advantage of that.
And as a sort of an aside, your new Massachusetts rules that will come into effect in January have a provision where the court and the parties talk about preservation, so you're ahead of the proposed federal rules amendment. And then two more parts of Rule 16B. Yeah,
one of the issues for conversation or discussion at the Rule 16B is any agreements that counsel have reached, and agreement under Federal Rule Evidence 502. And this, I think, is extremely valuable, and the reason it's extremely valuable is that lawyers still, most of them, don't know about 502 and don't know the benefits of a Rule 502 order. I think one of the reasons is that it's in the Federal Rules of Evidence rather than in the Federal Rules of Civil Procedure, but it didn't have to be put in the Federal Rules of Evidence, but it had to be passed by Congress. The Rules Committee could not make this amendment on their own because it changes the substantive law. And the Rules Enabling Act only allows the rules to deal with procedures. And you'll see, again, when we get to sanctions, how they had to dance around that issue in connection with preservation. So this was a rule passed by Congress, but it's very, very valuable. And what it does is, if a court enters a 502D order, the court has to enter an order basically stating that the disclosure, whether inadvertent or purposeful, of privileged material or work product protected material is divulged, it's not a waiver, not only in this case, but in any other case, either state or federal. And what this does is gives you an added level of protection, especially for clients who are engaged in multiple litigations in multiple jurisdictions. Because if for some reason a document slips out and is revealed, attorney-client, that shouldn't have been revealed, and but it was shown, it's shown to a third party, which can operate as a waiver of the privilege. If you have an agreement that if anyone inadvertently produces this privileged material, the other side will immediately give it back. That protects you in that particular litigation. But it doesn't protect you in other litigation, because you may be sued by Company X in Idaho, and they may say, well, we weren't a party to that agreement, and you disclosed that to a third party, therefore you've waived the privilege. 502D protects against the adverse consequences of disclosure of attorney-client privileged material or work product protected material in not only the instant litigation that you're in, but also any subsequent litigation, federal or state. So that's an important thing, I think, to have on the agenda at that time. There are some lawyers, some judges, like Judge Grimm down in Baltimore, who are automatically issues a 502D order in every case. I do not do that, but if something comes up that indicates that it would be necessary, I bring it to counsel's attention. But I've never gotten a request to enter one. It's always sua sponte that I say, I think you might need one in this case.
And there are some judges who have expressed the opinion that a lawyer commits malpractice who does not ask the court to enter a 502D agreement. So you may want to take a look at 502D if you're not familiar with it. And the last provision is an interesting one. The rules now require the parties to confer before any sort of motion to compel is filed. This is an addition which specifically directs a moving party request a conference with the court before moving for an order relating to discovery. And I can see, Judge Collings, the parties can't agree on this, and we're going to file a motion to compel. We want a conference with you. So what are you going to do?
I'm not sure that that's a good use of judicial resources, because suppose we do have the conference and each side gives me all their input on it. Either I've got to resolve it at that point in time, or I've got to say, oh, okay, you can file a motion to compel, in which case we go through the whole thing again. It may be helpful in this respect. One of the problems we often have is that parties haven't sufficiently conferred in advance of filing a motion to compel. And I bring them in for a hearing, and I'm spending all sorts of time trying to figure out what the dispute is. What is actually in dispute between the parties? And sometimes even if I can't do it from the papers, I'll order them to meet and confer some more, or I'll do something, because, once I know what the dispute is, the contours of the dispute, then I can make a ruling. But when each side is all over the place, it's very, very difficult, and you spend a lot of time trying to get to the nub of the dispute. So that may be helpful in that respect, because if in a conference, I could make that directive directly to them.
The next amendment is the single most controversial of the new amendments. Let me give you some background. The current rule says that you can discover any non-privileged matter that's relevant to any party's claim or defense, or for good cause shown, you can discover the subject matter of the action. There is also another provision in Rule 26 called the proportionality provision, which allows a court to limit discovery to that which is proportional. It's been in the rule since 1983. In the 2000 amendments, and again in the 2006 amendments, it was reemphasized in the comments to the rules. And this proposal would move the proportionality language from where it is into the scope of discovery. So now, if this rule becomes a rule, this proposed rule, parties may obtain discovery regarding any information, non-privileged matter relevant to any party's claim or defense and proportional to the needs of the case, considering the amount in controversy, the importance of the issues at stake in the action, the party's resources, the importance of discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. And then it adds the current, similar to the current language, information within this scope of discovery need not be admissible in evidence to be discoverable. This is a major move to now make discovery not just relevant to the claim or defense, but also proportional, that you do a cost-benefit analysis before discovery can proceed. And Judge Collings, I'm really interested in what you think about this.
Well, I'm just thinking about what the objections to interrogatories and requests for production of documents are going to look like. You know, we object on the ground the discovery sought is not proportional to the needs of the case, considering the amount of controversy, et cetera, et cetera. We have enough problems with overbroad objections, and I'm wondering whether this is going to increase that. I mean, this is really just taking it from one part of the rules and putting it in another as to the scope of discovery. And I just don't know what effect that's going to have on the practice. It's sort of interesting. Judge Carroll mentioned the prior rule where it was a two-stage proceeding. You could gain discovery of matters relevant to the claims or defenses in the case and for good cause the subject matter of the litigation. I remember when that went in, and you probably do too, John.
2000, yep.
Yeah, you remember when that came in, and I thought to myself, oh my gosh, I could just see now we're going to have a whole raft of new litigation over whether something is relevant to the claim or defense or is something you need good cause for. That didn't happen. I never had a problem with respect to that. So maybe my fears about this are perhaps ill-founded or just not warranted. But that's the thing I think of just looking at it, that you're going to have this brought in immediately to into any request for discovery.
And I think that's everybody's fear. The reason for the rule change, I think, is as the doctrine of proportionality has developed, what it has communicated to courts is to do sort of phased-in discovery. I've heard the phrase used, let's discover the low-hanging fruit first and then see what we need to do. So I think, again, this is intended to communicate to the court that you need to do the least expensive version of discovery first to see where it gets you. And in fact, you may get all the discovery you really need in order to try your case. But it is a major shift that now, I think Judge Collings is right, you will see objections that this discovery is not proportional. The other problem is at this stage when you will get these objections, which is immediately at the beginning of discovery, you really don't, if you're the court, you don't have a feel for the case.
Exactly.
You know, what it really is like. So that's why I think this is the most controversial, and it certainly in the early hearings before the advisory committee, this has been the most controversial. On the other side, there are strong proponents that believe this is absolutely important. The only way you can cabin this excessive discovery is to deal with a proportionality issue at the outset rather than after you've gone through a lot of discovery. But again, it is designed to communicate to courts to do phased discovery rather than let everybody have everything right away.
I have no problem with phased discovery. In fact, I suggest it quite often. One of the problems, especially in the electronic area, is that you don't want to do phased discovery if you're going to have to repeat it if the discovery in phase 2 or phase 3, and because that's just adding to burden and expense. But if you can just do limited discovery and then reassess without having to repeat a lot is beneficial. The other thing I do is, in my cases, is urge them to build into the schedule a period of time, if they're willing, to go to mediation. In Boston, all the magistrate judges do the mediations. And I try and build it in so that they've done what I call the crunch discovery, or the discovery they really need to do to evaluate the other side's claims or defenses for settlement purposes and then build in settlement. So that's another technique I use.
The next is this proposed amendment about cost shifting, Judge.
That is basically a codification, I think, of what we have the power to do now and what we've been doing. When you issue a protective order, the court has wide discretion as to a fair allocation of costs, and I think that just codifies it in the rule.
And I think Judge Collings is right. There are lots of cost-shifting opinions, but what this will allow you to do as the producing party is say, if we have to produce this information, shift the cost of production to the requesting party. And again, as an aside, the new Massachusetts rules that come in January have language about allocation of expenses in them. So again, you're a little bit ahead of the curve. How about the issue about this new serving Rule 34 requests early?
Well, I think actually that's a pretty good idea. And again, it sort of helps the parties to get a sense of the scope of the discovery a little bit earlier. It permits that a party to deliver Rule 34 requests 21 days after the summons and complaint have been served, but they're not considered actually served to start the 30-day response period until the 26F conference. But what it does do, it enables a party, first of all, to get out on the table what they want and have time to consider that, so that when they go to the 26F conference, it's obviously an ideal time to meet and confer and try to work things out. This one, I think, is a decent idea.
And I think Judge Collins is exactly right. This means you can serve, or you can provide Rule 34 requests to the other side. They're presumed to be served at the 26F conference, but it gets discovery on documents going much, much sooner than currently allowed by the rules.
And it also gives you a greater hint as to what you need to preserve.
And how about the Rule 26F 502 provision?
Yeah, this is really what I've talked about before. We saw in Rule 16, it made it an agenda topic for the Rule 16B conference. This adds it as an agenda topic to the 26F conference that the parties are required to put in their discovery plan, views and proposals on first of all on preservation, and because preservation's been added as an agenda item to the 16B, and also 502 orders, which have been added as an agenda item. It's interesting that in the progress of the rules, this 26F follows 16B, whereas on a timeline, it's 26F then 16B. But they're basically making it the two rules coordinate.
And again, real emphasis in these new amended rules on Rule 502. It came into being after the 2006 amendments, and I think everyone in the federal court system believes it's a very, very important rule that, again, is not getting nearly the attention that it deserves. What about all these discovery, changing the limits again, Judge?
Okay, well, I have real doubts as to the effectiveness of this technique, but obviously the reason they're doing it is they're trying to reduce costs. The wild card in it is that the parties can stipulate out of it under Rule 29, as long as it doesn't delay a trial date, or there's other language indicating that it doesn't otherwise interfere with a scheduling order. So, I don't know how effective they are. I know why they're doing it, and certainly what it will enable, if the parties can agree, is that a party's going to have to get leave of court to do more than 5 or more than 6 hours or more interrogatories, and they're going to have to make a showing as to why they need it. I think if they make a halfway decent showing, the presumption is by the courts is that we'll let you do it. It just, I suppose, requires parties to think a bit more about how they're going to use their discovery techniques, and keep in mind that under the rules anyway, they start off with a lower number.
Francis Fox and I were on the advisory committee when we decided that the right deposition length was 7 hours, and I'm damn mad they're changing it to 6. Okay, now we're going to get to these proposed rule amendments, and again, Judge Collings is going to take the lead on this, which is going to require lots more specificity and objections.
Yes, the proposed amendments to Rule 34 requires that objections to requests must be made with specificity. And this, actually, our local rules require this, but it's honored more in the breach than in the observance, because everyone wants to cover themselves. So they object, and now with word processors, all you have to do is press the button, and it's overburdensome, the whole litany of terms that they use. This is really emphasizing, again, on specificity. And it allows for production of copies of ESI, but it doesn't change the basic thing about requests, and the important thing about requests is that you specify on the request the format in which you want the documents produced. That's very, very important, because if you don't do that, the other side has a fallback that may not be the particular way you want it. And 3 is really responsive to a pet peeve of mine, but I don't know if the Rules Committee even knew it was a pet peeve of mine.
Sure they did.
You get these objections. We object on ... Notwithstanding the above objection, we will produce the documents. Well, the other side has no way of knowing whether or not, on the basis of those objections, you're withholding anything. And they have the right to know if you're withholding anything on the basis of those objections. And this amendment requires an objection must state whether any responsive materials are being withheld on the basis of that objection. I tell you that this sort of carries on the theme that I was talking about earlier about getting down to what is actually in dispute. Because if you make these boilerplate objections and these general objections, they're not really helping to figure out exactly what's in dispute. So again, this is an effort to try and get the parties to narrow what they actually are disagreeing about, and that requires the objections to be specific, and again, requiring that if they are withholding something, they have to say so. I think that's a very, very salutary amendment.
And if you've looked at rules packages over the years, the more open and public the rules process has become, the more the rules package try to give something to both sides. The proportionality, moving it to scope, was clearly something that the defense side wanted. This is something that the plaintiff side wants, which is to eliminate the boilerplate objections and to eliminate any knowledge about what's going on. I agree with Judge Collings. Lots of courts are doing this anyway, and these are very, very valuable and intended to respond, again, part of the proportionality argument also involves Rule 26G, and I'm often asked people, and I won't ask you all if you remember Rule 26G from your civil procedure course, but read it sometime, and it will tell you what you are certifying when you sign a discovery request or a response to discovery. And it's sanctionable conduct for you, quite frankly, to do the kinds of things that's common practice. So this is a really good, I think, common sense. Regardless of what happens with the more controversial parts of the amendment, I'm confident that this will come through.
Rule 26G is basically the Rule 11 analog in the discovery context, and I know you all are familiar with Rule 11. Well, Rule 26G is the same type of application to discovery.
Rule 36 has previously been sacrosanct to any sorts of limits on the number of requests for admissions, and this would limit the number of requests for admissions to 25.
This is just more of the same, but I must say that I've never had a situation where someone told me that the other side propounded too many requests for admission. It's really been a non-issue.
We want to spend a chunk of time talking about Rule 37 because that is a major change in these new amendments to the way things are currently done. Rule 37 is the sanction motion. As Judge Collings indicated at the beginning, preservation is probably the hottest topic in the e-discovery world because sanctions flow from the failure to preserve. There was a huge move early on to put some sort of a preservation rule to make the duty of preservation clearer than it currently is. As you know, that you're required to preserve relevant information when you know or should reasonably know that litigation is going to ensue. And the defense side particularly thinks that's a very amorphous concept that judges have applied in variously bad ways. The Rules Committee did not touch that, mainly because everyone thinks there are serious Rules Enabling Act issues that relate to that. But they did radically propose changes to the sanction rule. First Amendment is it specifically makes failure to produce conduct which can be sanctioned. If you look at the present rule, it really doesn't say that if you don't produce the information, you can be sanctioned. This eliminates that idea. And then it develops a new concept, the concept of curative measures, and separates out the concept of curative measures from what sanctions are, imposes a particular state of mind for the imposition of sanctions, doesn't impose a particular state of mind for the imposition of curative instructions. So with that in mind, let's look at the specific language. It says that the court, when there is a failure to preserve, may take certain curative measures, like ordering additional information, requiring the party which failed to preserve to restore or obtain the lost information, pay reasonable expenses, permit introduction at trial about the loss of information, or allow jury arguments. These are powers of the court now in Rule 37 to essentially remediate the problem caused by failure to preserve. They are different than sanctions, though. These are sort of common sense. The court is going to try to remediate the difficulty. If there is a failure to preserve that's negligent or a failure to preserve that's simply a mistake, the court is going to try to remediate that as a first step. Only if the court can't remediate that will you get to the issue of sanctions. So the first thing the court under the new rule is designed to do is remediate the effect of the failure to preserve. However, if the court can't remediate that effect, then it kicks you into the sanction portion of the rule, which is the court may impose any sanction listed in the rule, and that's default judgment, dismissal, those sorts of things, or give an adverse inference instruction. And here's the most substantive and important part of the new rule. It codifies the state of mind that a court must find before sanctions can be imposed. It remedies the difficulty now where the Second Circuit can impose a sanction including an adverse inference instruction for negligent conduct or gross negligence. It eliminates that possibility. So the court now under the rule can impose any sanction including an adverse inference instruction if it caused substantial prejudice in the litigation and were willful and in bad faith. Willful and in bad faith. So that's the new standard. You look at the state of mind, which is willful and in bad faith, or you look at the prejudice. How substantially was the party prejudiced? And then there's one more, that even if you find that there was not willful and bad faith conduct, but that the failure to preserve irreparably deprived a party of any meaningful opportunity to present against or defend the claims in litigation. This comes out of the Silvestri case in the Fourth Circuit where the plaintiff let the van, which was the subject of a products liability case, get destroyed. Didn't do it intentionally or in bad faith, just did it by accident, turned it over to a garage and the garage destroyed it. This allowed the case to be dismissed because the party can no longer defend. So this codifies the new rules. What's the state of mind? What do you have to show before sanctions can be imposed? Judge?
Yeah, this is really a major effort to get some uniformity in the area of sanctions for allegations of spoliation of evidence. And you can see how they skirted the Rules Enabling Act problem, because they didn't change the law as to what your responsibility is. It's still that you've got to preserve any material relevant to litigation that you reasonably anticipate. That remains the same, but what they did do was to limit the sanctions that you have can be imposed upon you and require that sanctions only be imposed in certain really egregious situations. Frankly, I'm not sure that, as a practical matter, that's that much of a change from what's gone on in the case law. I mean, if you look at it, most of the time when really bad sanctions were imposed, the parties' activities were pretty egregious. And so I'm not sure that it changes that much, but it certainly tries to make things uniform. The real problem is what do you do, and this is what I alluded to earlier, when you acknowledge that a claim is likely to be filed against you, the claim isn't filed, you only have sketchy information about what it's going to entail, but it at least clear that it triggers your responsibility to preserve. And what do you do in a situation like that? What we were talking about this last night, what our advice to you is that you act reasonably. Well, that's really helpful, I know, I'm sorry, but that's going to be the key. Not only do you act reasonably, but you document exactly what you know, what you did in response to the obligation to preserve, which clearly had arisen, and why you did it. And it seems to me that that will be a substantial protection for you, even between now and December 1st, 2015, and when these rules, if they do, go into effect. I think that protects you now, and that, I think the judges understand that when you are faced with a spoliation motion, there's a lot of 20/20 hindsight because you know a lot more about the case later than you did earlier. But if you act reasonably in good faith and you document it, I think you're going to be protected. And the reason behind this is simply that the industries were over-preserving at huge costs, and that's the reason that this rule is in effect as to. Then they did it because they were afraid of being sanctioned. Well, this sort of tightens up on what you could be sanctioned for. But the process that parties should undergo when they learn about a claim, an anticipated claim, it really remains the same and should probably remain the same after the rule goes into effect, if it does.
Let me make one correction. I typed my own PowerPoints. It should be willful or in bad faith, not and in bad faith. The rules change is willful or in bad faith. Same comments still apply, that this is an attempt to codify the sanction to eliminate the possibility that negligence or gross negligence can result in the imposition of sanctions.
Maybe you ought to have you do that audit that the prior speaker talked about.
That's right, that's exactly right. Okay, the proposed rule also sets out a series of factors to determine whether or not sanctions ought to be imposed, the extent to which the party was on notice, and there again, the reasonableness of the party's efforts to preserve information, whether the party received a request to preserve, and then proportionality again appears in the rule. So, questions? Yes?
I'm a civil procedure junkie in addition to a Google Glassware. So on 26B1, I think the source of the controversy is that people on both sides of the fence really believe that it's going to have an effect on how much discovery is done. That's not simply a relocation of existing language somewhere else. It's actually going to affect how much discovery is accomplished. And my sense, and correct me if I'm wrong, is that in general, plaintiffs, lawyers tend not to like this proposed change, and defense lawyers tend to like it. Maybe that's not right.
No, I mean, the comments at the most recent advisory committee, that's exactly the way it falls down. The plaintiffs' bar very, very seriously opposes this.
Yeah, I'm not surprised. So I guess my question is, do you agree with the characterization that it is going to have an effect on how much discovery occurs, and that in general it would tend to disadvantage plaintiffs relative
I'll let Judge Collings answer first.
Thank you very much. I really can't say if it's going to have that effect in the end. As I indicated before, they had that two-stage thing in 26B1A, and that just didn't, never generated any controversy. I think in the end it had really no effect on the limits of discovery, and I think that for plaintiffs, if they have, legitimate discovery requests, I think the court is going to overrule any objections based on that. I think what it may have some effect in the sense that it's going to require, people are going to start thinking about, plaintiffs' lawyers are going to start thinking about it. Do I make these huge requests so that I make sure that I catch every nugget? Or perhaps my request going to be a bit more limited because I don't want to be thrown out on the grounds that an objection based on proportionality. It's really very difficult to see, and a lot's going to depend on how the parties deal with it, and a lot's going to depend on how the judges deal with it. And I agree with what Dean Carroll said, is that one of the problems this discovery is early in the case. And you're not going to have that good a handle on the case, the whole thing about the needs of the case, the amount in controversy, the parties' resources, and all that sort of thing, which usually was applied after the parties had done discovery and are looking for more, or had at least done some that was not subject to that objection, and you get into a point where they want more. And then the court would perhaps invoke that provision as it exists now. But it's never been done up front, and I'm just not sure as to how it's going to play out. I can't believe that it will prevent a party from getting legitimate discovery in the end. I think it will just narrow things, and if it does that, it's helpful.
Yeah.
Yeah.
It's a matter of, at this point, what's unclear is if they make a proportionality argument at the point of 26, when they receive a request, or when they're discussing the scope of discovery with opposing counsel, if someone doesn't like the scope, who has the burden of going forward?
The one that.
Do you need to bring a motion for protective order, or like with not reasonably accessible, does someone else need to make a motion to compel?
No, I think it could be either, frankly. It could be it could be the objection stated on the record based on the new rule, and then they'd have to file a motion to compel if they couldn't work it out. I suppose there is a room for a protective order if someone serves the document request pursuant to the rule 21 days after the service of or whatever the time frame is, the early Rule 34, the other side looks at it and says, my God, you perhaps after discussing with the other side, if you're not going to make any progress, file a motion for a protective order to limit it. That's a possibility, but I think more often it's going to be a motion to compel based on objections.
And again, you now have proportionality language in the Massachusetts Rules of Civil Procedure for the first time, so.
Francis, one last question.
Francis.
I'm on the American College Rules Committee, and last week we suggested to the full college that they issue with willful or bad faith. Bad faith in and of itself is the only way you get sanctions. And what does willful add to it? If it adds something to it, should it be added? What is your view on why those two terms are available?
If you read the advisory committee, they wanted to be able, I think it's clear that negligent and grossly negligent conduct, willful, there may be a situation where there's not bad faith, but there's willful destruction. And I think they're trying to encompass that term. Now, having said that, someone at the last meeting I was at said that they went through the appellate decisions, and there are like 25 different interpretations of what the word willful means, so that leaving willful in is going to continue to leave great uncertainty.
That's not a good thing.
Yeah, so willful or in bad faith, and it's the willfulness that's getting everybody concerned.
It's hard to see how you, if it were a willful destruction, how it wouldn't be in bad faith when you think about it.